the judge has ordered that all business licenses held by Donald Trump or by Trump Organization entities that authorize them to engage in real estate transactions in New York are revoked. The effect of this ruling is immediate and total. Trump cannot buy property in New York. He cannot sell property in New York. He cannot develop property in New York. He cannot broker real estate deals in New York. The business that he built over decades, the towers, the hotels, and the golf courses that carry his name, can no longer be managed or controlled by him in any official capacity. What I'm going to explain is how we got to this point, what the judge's ruling actually says in detail, what a permanent ban means in legal and practical terms, what happens to the existing Trump properties in New York, and why legal experts are describing this as one of the most severe penalties ever imposed in a civil fraud case in New York history. Here is the background you need to understand. The New York Attorney General filed this lawsuit in September 2022. The lawsuit alleged that Donald Trump, along with his adult children and senior executives of the Trump Organization, repeatedly and persistently inflated the value of assets on financial statements submitted to banks and insurance companies. According to the lawsuit, the purpose of inflating those values was to obtain more favorable loan terms and lower insurance premiums. The lawsuit cited several specific examples. It alleged that Trump claimed his triplex apartment in Trump Tower was nearly 3 times larger than it actually was. This claim resulted in a valuation that was inflated by tens of millions of dollars. It also alleged that the Mar-a-Lago property in Florida was valued at more than $700 million on financial statements, even though comparable sales and deed restrictions suggested a value closer to $75 million. The lawsuit further alleged that commercial properties owned by the Trump Organization were valued using methods that ignored market conditions and standard appraisal practices. The Attorney General sought $250 million in disgorgement, meaning the return of profits that were allegedly obtained through fraud. The lawsuit also requested a permanent ban preventing Trump and certain family members from serving in leadership roles in New York corporations. The case eventually went to trial. The trial lasted 11 weeks. During the trial, the Attorney General presented dozens of witnesses, including accountants, appraisers, and banking executives. The defense presented its own witnesses as well, including Donald Trump himself, who testified for several days. After hearing the testimony and reviewing thousands of pages of documents, the judge issued a ruling. That ruling is 92 pages long, and the conclusions in it are extremely severe. The judge begins by summarizing the evidence. According to the ruling, the Attorney General presented clear and convincing proof that financial statements submitted to banks between 2011 and 2021 contained material misrepresentations. The judge wrote that these were not minor mistakes or simple differences of opinion about valuation methods. Instead, the judge described them as intentional and egregious acts of fraud. The ruling then goes through several specific examples. Regarding the triplex apartment in Trump Tower, the judge found that Trump personally signed financial statements claiming the apartment was approximately 30,000 square feet, even though its actual size was around 11,000 square feet. The judge concluded that this was not an accidental error. It was a deliberate misrepresentation intended to inflate the value of the asset. The ruling also examined the valuation of Mar-a-Lago. The judge found that the valuation method used by the Trump Organization was not based on a realistic assessment of market value. Instead, it was based on a hypothetical scenario in which the property could be subdivided and sold as residential lots. However, deed restrictions and local zoning laws prohibit that type of development. The judge described this valuation approach as fraudulent. The ruling also addressed commercial properties owned by the Trump Organization. According to the judge, the appraisal methods used by the organization were inconsistent with standard industry practices. As a result, many properties were valued at 2 to 3 times higher than what independent appraisers would have determined. The judge wrote that the pattern of overvaluation was so consistent and so extreme that it could not reasonably be explained as accidental. Instead, the court concluded that it was intentional fraud designed to mislead lenders and insurers. One of the most important aspects of the ruling concerns intent. In fraud cases, proving intent is often the most difficult part. Defendants frequently argue that they relied on professionals, that they made good faith estimates, or that property valuation is inherently subjective. However, the judge rejected those arguments. The ruling states that Trump was directly involved in the preparation of the financial statements. He reviewed them, signed them, and either knew or should have known that the valuations were significantly inflated. The judge also noted that when accountants or lenders raised concerns about the valuations, Trump and his executives dismissed those concerns and continued using the inflated numbers. The judge wrote that the defendant demonstrated